Out of food, we'll try to have more next time. My name is Caleb Hunt, and I'm the proud president of the Washington University Federalist Society chapter. I'd like to say thank you to our friends with the Immigration Law Society for co-sponsoring this debate, and thanks to all of you for taking your time to come today. I promise you it will be time well spent. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of legal order. We boast over 70,000 members nationwide, including prominent judges, politicians, and scholars. We are founded on three simple yet profoundly important principles, those being that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what the law should be. That said, it is certainly not our chapter's goal to propagate a single partisan viewpoint. Rather, we are passionate about engaging with a diversity of perspectives to spark conversation and foster learning. We strive to serve this goal by sponsoring discussions, panels, and as with today, debates. It is a great honor, therefore, to introduce our debaters who have graciously agreed to participate. First, I would like to introduce Professor Josh Blackman, who is an associate professor of law at the South Texas College of Law in Houston and specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of the critically acclaimed Unprecedented: The Constitutional Challenge to Obamacare, as well as Unraveled: Obamacare, Religious Liberty, and the Executive Power, published by Cambridge University Press. Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Professor Blackman has twice testified before the House Judiciary Committee.
With this guy, by the way. Last time we sat at a table, we were both under oath. This is a big upgrade.
Indeed. With that guy. Regarding, let me lose my spot here, sorry. Regarding immigration and healthcare executive action. He's an adjunct scholar at the Cato Institute. Professor Blackman is also the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league, and blogs at joshblackman.com. Professor Blackman leads the cutting edge of analytics as director of judicial research at Lex Predict. Professor Blackman is the author of over 36 law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. I would also like to introduce Professor Stephen Legomsky.
That guy.
Yes, that guy, who is the John S. Lehman University Professor Emeritus here at Washington University. His immigration law textbook, now in its 6th edition, has been the required text at 185 law schools since its inception. He took a leave of absence for 2 years to serve in the Obama administration as chief counsel to the Federal Immigration Agency. After retiring in 2015, he was called back to Washington to serve as senior counselor to the Secretary of Homeland Security, Jed Johnson. He has testified before Congress many times with this guy. Testified before Congress many times and has served as consultant to the administrations of President Clinton, the first President Bush, to the UN High Commissioner for Refugees in Geneva, and to several foreign governments on immigration and refugee policies. He has been appointed to visiting positions at Oxford University, Cambridge University, and other universities in the United States, Mexico, New Zealand, Switzerland, Germany, Italy, Austria, Australia, Suriname, Singapore, Israel, and Portugal. Professor Legomsky has just published his first novel, The Picobdilema, is that how it's pronounced?
It's a made-up word, so you
There you go. The Picobdilema, which is a science fiction novel set in St. Louis. The book explores what it means to be living and whether there are ethical and personal hazards in pursuing eternal life in a laboratory. It is available online in both paperback and digital format at booklocker.com and on Amazon Books, and locally at Left Bank Books. Please know there will be a time for questions and answers at the end of both presenters' remarks, so as you consider what questions you might ask them, please do try to keep them clear and concise. Thank you.
Thank you.
Yes.
Wonderful. Thank you so much. It's my first time in WashU. Again, the last time, Professor Legomsky and I had the pleasure of sharing a table. We were under oath. I was on the right side of the table. He was on the left side of the table. We were testifying about President Obama's executive action, immigration. You were all fortunate to have him in your community. Even if he's not teaching classes, he's still an asset to your campus. So I'm grateful today to talk about the travel ban from President Trump. Before I get to the case, I want to discuss another case that you may have studied in constitutional law, a case called Texas versus Johnson. This case considered whether a person can be arrested for burning the American flag as an act of political protest. Now, the decision broke down in a 5-4 line, but to the surprise of many, Justice Scalia, who actually died 2 years ago, I think today, Justice Scalia cast a deciding vote in favor of the flag burner. Now, Scalia was no fan of flag burners. He once said, if it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag. Scalia said, but I am not king. Now, indeed, Scalia felt the answer was compelled by the Constitution, the First Amendment, even if he disagreed with the result. Texas versus Johnson is a good gut check for lawyers. If your understanding of constitutional law overlaps entirely with your own philosophical beliefs, you may want to reassess the former. This is much how I feel about the travel ban. I'm a libertarian, and I generally favor open immigration policies. I think the idea of banning the entry of aliens from certain nations merely because those nations have been associated with terrorism is awful policy. These executive orders will cause hardships to families, refugees, and people seeking to build a better life. I'm also doubtful the policies will do much good for national security. Yet, with my cards on the table, I have argued consistently for some time now that Congress gave the President the powers to make these orders, and the Constitution does not bar him from exercising these powers in the manner in which he did. So I'm going to try and cover 5 parts in my brief time here, and they are keeping time. First, I want to walk you through the history of the travel ban. There have been now 3 iterations of this policy, including statements made by then-candidate Trump. Second, I will talk about the various decisions of the courts which halted these 3 iterations of the policy. Third, I want to discuss whether Congress has afforded the President the power to take these actions. Next, I'll talk about whether these actions conflict with the First Amendment, namely the Establishment Clause. And finally, I want to give you a preview of the Supreme Court's upcoming arguments in the case of Hawaii v. Trump, which should be argued, I think, in about 2 months or so. We don't have a date, but it should be in April at some point. So our story begins before the election, in fact, before President Trump was a nominee, back in December 2015, when no one gave him a chance, right? Then candidate Trump called for, quote, a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. He said it. Over the next few months, Trump shifted his position, at least externally, from a Muslim ban and said now he wants extreme vetting of people from certain territories. Or did he? Cue PolitiFact, right? During a July 2016 interview on CBS's 60 Minutes, Trump told Leslie Stahl, call it whatever you want, but we'll call it territories. Was this a repudiation or a wink of the nod to the alt-right? However, a week later, on Meet the Press, Trump seemed to repudiate the policy to Chuck Todd, saying, I'm talking territory instead of Muslim. Did he really mean it, or is this fake news? Alas, the burden of reconciling these statements has fallen from fact-checkers to the federal courts. Judges have now looked at the president's statements, tweets, and other press releases as evidence that his initial animus towards Muslims infects, that is, taints the subsequent policies. I'll come back to this a little bit later, but the important point is, on January 20th, he was inaugurated. 1 week later, January 27th, the president issued his first executive order on immigration, and it sent shockwaves through our system. For 90 days, certain aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen, 7 countries, were deemed detrimental to American interests. They will be denied entry to the country. And the refugee admission program we suspended for 120 days. In particular, Syrian refugees, we denied entry indefinitely. Now, almost immediately after this first order was signed, airport officials started detaining nationals who arrived. Imagine, you got on a plane in London or Spain or France, and you get papers in order. As you were flying through the air, the president signs this order, and you land at an airport, and you can't enter. Now, this may surprise you, but when you are at an international airport, you're not on U.S. soil to clear customs. You're still in this weird nether region. Even if you're in the middle of the country, Chicago, whatever, right? You're not in the country yet. Judges start issuing emergency orders saying you have to release people, especially those with green cards, who had a statutory right of entry. But this was only the first round of the lawfare. Shortly thereafter, a judge in Seattle issued a nationwide injunctions. Steve and I took at nationwide injunctions with DAPA. Now you have them with the travel ban. They issued a nationwide injunction barring the order from being in effect anywhere, really in the world, where a U.S. official is present. This was appealed to the Ninth Circuit. The Ninth Circuit ruled in favor of Washington. They ruled against the Trump administration. Trump did not take that case to the Supreme Court, probably a wise move. Instead, he said, I will do a do-over. And a second executive order was signed in March 6th. Now, the second executive order had a few big differences. So first off, it took Iraq off the list. It also said if you have a green card that is your lawful permanent resident, you are not subject to the ban. The order also made some findings that the reason why these people are being denied entry is not because they individually pose a threat, but that their nations are not sharing adequate information. There's not proper sharing of identity management, as it's called. For example, Libya, Somalia, and Sudan provide some cooperation. Iran and Syria provide zero cooperation. Okay. This order was also challenged in courts. This time, Hawaii got there first, and a federal district court in Hawaii issued another nationwide injunction against the travel policy, followed shortly by a judge in the District of Maryland. So you had these two nationwide injunctions clashing, right? They mean the same thing. It was appealed. The Ninth Circuit upheld it. The Fourth Circuit also upheld it, and what they did was they sat en banc. That is, all the judges in the Fourth Circuit sat together at the outset. And they wrote a very long opinion, which I unfortunately read, basically saying that this order drips with animus. It's dripping with animus, like a vampire blood coming. That's what they described it as, right? Okay, that case then was appealed to the Supreme Court, but they sought what's called a stay to put the orders on hold. The Supreme Court let the order go into effect in part, saying that people with a close relationship should be allowed to enter, but they don't have this sort of close relationship, bona fide, the word is, they can be denied entry. But this was only a temporary decision, because we knew that this second policy had a shelf life of 90 days. That 90 days ran out in September 2017, when we get travel ban 3.0, what's called the Proclamation, right? The first two were always meant to be temporary, not final. The third one from September was the final one. And now there were 8 countries on the list: Chad, Iran, Libya, North Korea, Syria, Venezuela, and Yemen. Now, no one cares much for North Korea. They don't send too many people. They're just cheerleaders, perhaps. But, they don't send many people to the United States. But it's fawning over North Korea makes me sick. But that's for another debate. As well as for Venezuela, these are a small number of diplomatic officials affected. So primarily we're dealing with 6 Muslim nations, right? That we're still dealing with the same constituencies. Now, this was actually performed after a fairly lengthy review. The Secretary of Homeland Security reviewed hundreds of countries. Are they sharing information in an adequate fashion? And the President adopted the Secretary's recommendations. So this policy is now in the court system. And it went through the courts. Again, shocker, shocker. District courts in Hawaii and Maryland found they were illegal. Circuit courts were appealed. Circuit court said, you're right. Went to the Supreme Court. Then the court did something a little bit funky. They basically allowed it to go into effect. Right? I don't want to go into the nuances of state laws, but the court could have stopped it. And they didn't. They allowed it to go into effect. There were some dissents there, but the court as a whole allowed it to go into effect. This told me, from sitting at my vantage point in office, that at least 5 of the justices were comfortable with this policy. In fact, on the Roberts Court, where Justice Kennedy votes to grant a stay, in every single case the side he voted for wins. I think one exception I can think of. So as a general matter, when the court grants relief to one party like this, that party wins. So that was my first sign, okay, maybe the courts of appeals are out of line. The court then granted certiorari about 2 months ago, and it's going to be argued, if I had to guess, the second or third week in April. I will be there, God willing, to report back to you. Okay, that's the background. I haven't made an argument yet, but that's just as long as it takes to explain the damn case. Now I want to go through the actual legal argument. We always start with the statute, right? The president gets power from two sources, Constitution and acts of Congress. This is Justice Blatt's opinion in Youngstown. I'm not going to rely on the constitutional argument, but it does exist. In a case called Knopf in the 1950s, the Supreme Court said the president has an inherent power to exclude, an inherent power to deny entry. That's lurking in the background. I'm not going to say much more about that, but in all of my statutory analyses, I contend the president has both statutory and constitutional authority. Let's just talk about the statute. 8 U.S.C. 1182F says, I'll read it to you. Whenever the president finds that the entry of any aliens or any class of aliens would be detrimental to the interests of the United States, he may by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens and restrictions he deems appropriate. This is a really broad delegation of authority, really broad, with almost no guidelines. In fact, the libertarian in me says this probably violates a non-delegation doctrine, but for Article 2. See, I think this case would probably turn out the same way if Congress never enacted the statute. It's a little bit easier for the president with the statute. I don't think he needs it. But when the president has statutory authority and his own constitutional authority, under Justice Jackson's framework in Youngstown, he's in the first tier. And their court scrutiny is at its minimum, the exact opposite of what the court's been doing. But this statute puts almost no limits on the president's ability to exclude people. It doesn't require to make findings of fact about why one person might be dangerous. It's broad. In fact, President Reagan and Carter used this to deny entry to Cubans and Iranians back in the 70s and 80s. There was no argument that was illegal. Now, granted, they were for short durations of time. The Iranian hostage crisis had an endpoint, right? The Cuban debacle had an endpoint. We didn't know that. Hindsight's 20/20. We had no idea. And in fact, the Fourth Circuit, I was actually arguing, suggested, well, Reagan maybe broke the law too. Okay, go with that. That is not the above. Okay? So I think the president has the statutory authority to take this action. There's another statute, Section 1152, right? And it provides that no person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of residence, right? This was part of the huge Immigration Nationality Act by President Johnson, this discard of our quota system, right? It revolutionized immigration laws. So you might ask, well, Josh, you know, the first statute came in the 1950s, this one was enacted in the 60s, later in time controls. But there's not a clash, right? There's not a clash, right? The first statute speaks of entry, right? Deny entry to the country. The second statute is about the issuance of visas, and these are different acts. A person can enter the country, but not have a visa and be turned around. Now, I'm going to rebut myself. The third order does concern the issuance of visas. In fact, the third order does put limitations on who can get visas, so my argument is, in this case is not fully correct. But let's read subparagraph B of the statute. Nothing in this paragraph shall be construed to limit the authority of the Secretary of State, and now DHS, to determine the procedures for the processing of immigrant visas, applications, or the locations where such applications will be processed. That key word, determine the procedures for the processing of visas. My prediction, that's where Trump wins, right? The fact the statute says the president can use the procedures he wants will mean this is a procedure. And the reason why I say Trump wins there is that this allows the court to avoid the really tough constitutional questions. By reading the statute in the manner I've argued since last March, I've been very consistent on this one, the president can be upheld within his statutory authority. There's some case law on this with the Haitian boat lift, maybe we can talk about this later, right? But that is the nub. The president can determine the procedures, even if it involves nationality-based discrimination. One note, this statute doesn't mention religion, which takes my next point. It says race, sex, nationality, place of birth, etc. Not religion. Why? Now, this bridges my second point, the Establishment Clause. This may come as a surprise to you, but in our immigration laws, for decades and decades and decades, we do things that would violate the Establishment Clause. I'll give you a very easy example. During the 1980s, Senator Frank Lautenberg of New Jersey proposed an amendment, which is commonly known as the Lautenberg Amendment, that would basically give preference to, quote, Soviet Jews and evangelicals who are seeking to come to the United States. They had, I won't bore you with the details, but they had an easier path to get a visa than someone who was not a Soviet Jew. If Congress passed a domestic statute that says Jews and evangelicals get special treatment, my God, that'd be unconstitutional in 5 seconds. The ACLU would be suing it, it'd be shut down. Quick thing to say Roy Moore, right? It'd be done. But this law has been in the books for decades. Let's go back even further. There is a preference in immigration law for ministers, right? If you are a minister, you get a special dispensation, you get a visa quicker. It's been in the books for decades. How do they define minister? They say, well, it's someone who has like a lifetime vocation, like a nun or a sister or a monk. The regs in the statute actually reference Catholic doctrine as people get preference for visas. My God, if this was domestic statute, it'd be unconstitutional in 5 seconds. So I've come to the conclusion, and I've been arguing this for a year, and no one's replied to me yet, that the First Amendment just doesn't have application abroad. That the Establishment Clause is for our community, for our nation, not for people abroad. In fact, we do consider religion in asylum cases. There's a lot of entanglement that goes on that I don't think would fly in the domestic context. The courts never address this question squarely, but I can't find any authority to the contrary. So I don't think the court strikes us down on Establishment Clause grounds, and even if I'm wrong, mark my words, the Supreme Court is not going to write an opinion about tweets. But I know lower court judges love Twitter. They say Twitter every 5 seconds. The Supreme Court of the United States is not going to strike down the president's policy based on his Twitter or statements as a candidate in the campaign trail. It's not going to happen. The lower court judges, they had their fun while they had it, but this is over. The Supreme Court, I think, is going to rain down this parade. So ultimately, I think the court's going to uphold the policy. The fact that they issued the stay, that they put the lower court's opinion on hold, signals at least 5 justices, maybe 7, maybe 6, I don't know, are okay with this. Okay? Now, what happens next? Even if the court upholds this policy, right, it has to do a lot of housekeeping, right? There's a lot of other subsidiary issues, for example, standing, the various parts of standing. Were the injunctions properly scoped, right? Can you have a nationwide injunction? Is this issue moot? Because a lot of these people can be gaining entry elsewhere. I'm going to put those aside for now, but I wanted to focus on this last point, and I'll turn it over to Steve. These are really important separation of powers cases. This is not a near statutory thing about whether someone petitioned for a visa for a husband and because he was a member of the Taliban he didn't get a visa, right? That's mundane stuff. This is big league, if I may. This is big league stuff right here. And the decision the court cites will be cited for decades to come. You're reading your casebook, Youngstown, Dames and Moore v. Regan, right? These are the big cases, and I think the court recognizes the gravity of this. A lot of these lower court judges, I think, have been reacting to Trump in an improper manner. They've treated Trump in a way that no president's ever been treated before. Now, maybe Trump deserves it. I don't know. Maybe I'm right, maybe I'm wrong. But if any court is going to throw the president out of bounds, let it be the Supreme Court, and not these lower court judges who I think have been really out of line, and a lot of them have egg on their face after the court's decision. I will stop here, turn over to my good friend, Professor Legomsky, and I welcome your questions later. Thank you so much.
Well, thank you very much. Thank you very much, Josh. Let me join in a warm welcome to WashU for you. We really appreciate you being here, and I think you provided a wonderful background and identified the multiple legal issues in this case. Let me also thank Caleb Hunt. Where did you go, Caleb? Okay, and the Federalist Society for sponsoring this event, as well as Rebecca Moreland. Are you here, Rebecca? No? And the Immigration Law Society for co-sponsoring. Professor Blackman and I, as Josh has mentioned, have been on opposite sides of the immigration issue in a number of different contexts. But I want to say in all sincerity that I do regard Josh as one of the most effective advocates in the country for the conservative point of view on immigration. Which for shorthand purposes, Josh, I'll just refer to as the wrong point of view.
I'm right, you're wrong.
Okay, we can agree on that. There are multiple legal issues here, as Josh has indicated. Before we get into the high weeds of those legal issues, though, I don't want my own sentiments about the travel ban to get lost in these high weeds. It turns out they might be not that different from Josh's. I think the travel ban is horrendous national policy, just from the standpoint of our own national self-interest. But beyond that, and more importantly, I think the bigotry that it reflects and fosters is morally reprehensible. And I'll just leave it at that. I mention that because, in contrast, I do think the legal issues are close. I wish I could be more dogmatic about this, but I think reasonable minds can differ about the legal issues. There are multiple legal issues, as Josh has said. There are these preliminary issues, like whether the court even has the power to review the legality of the travel ban in the first place, and whether these particular plaintiffs have the standing to make the arguments that they do. And then there are the issues that go to the merits of the case. Time being limited, it's important to resolve the preliminary issues are. I'm going to focus solely on the merits issues. It seems to me that those fall into two categories as well, and you probably got this from Josh's presentation too. There are statutory issues and there are constitutional issues. I'll deal with the statutory issues first. It seems to me that they too break down into two categories. I'm sorry, well, they break down into two categories. Some of them deal with the scope of this 1182F or 212F of the INA, for those of you who have taken immigration law. This is a provision which, as Josh says, authorizes the president to ban the entry of, quote, any aliens or any class of aliens, unquote, whenever he finds their entry to be, quote, detrimental to the interests of the United States, unquote. We agree that this is a very broad delegation of authority from Congress to the president. Conversely, however, I hope we can also agree that this grant of authority is not unlimited. I don't think this provision can be read literally. If you really read this provision literally, then on Inauguration Day, the president could issue an executive order that says, I find that the entry of any foreign national into U.S. territory poses an unacceptably high risk to our national security, and therefore, for the next 4 years, no foreign nationals will be allowed to set foot on U.S. soil. That would completely upend the entire Immigration and Nationality Act, or the INA, which is the main statute that governs immigration to the U.S. And for that reason, it can't be read literally. I want to be clear, I'm not suggesting that President Trump's travel ban does anything remotely close to that extreme hypothetical. I offer that hypothetical only to establish a starting point for the debate. And the starting point is we cannot interpret 212F literally. Somehow, the courts have to draw a line through its literal language, and the only reasonable debate is over where precisely that line should be drawn. As to that, the plaintiffs are arguing that the president has crossed that line. They argue that he's exceeded the authority conferred by Congress in this 212F provision. And they make a couple of points. They observe that it bans, with some admittedly important exceptions, it bans all nationals of the named countries, as opposed to just those nationals who have certain definable characteristics that could be a reasonable proxy for the kinds of harms that the president says they will create if they are allowed to enter. Secondly, as Josh noted, they point out that the ban is indefinite in duration. Unlike the first two iterations, which at least had expiration dates, this one does not. They also argue, and we can talk more about this, that there really is very little correlation, if any, between the countries that are listed and the countries that the people who have committed terrorist acts in the U.S. actually came from. So all of those lead the plaintiffs to argue that the president has exceeded the 212F authority. The plaintiffs also invoke this other provision that Josh mentioned briefly, section 202A1A of the INA. This is the provision which says that no person shall be, and I'm quoting, discriminated against in the issuance of an immigrant visa. Actually, I've never heard it.
See, professional.
I've seen this provision so many times. In the issuance of an immigrant visa, because of the person's race, sex, and then the key word nationality, place of residence or place of birth, unquote. The travel ban explicitly discriminates on the basis of nationality, maybe even de facto on the basis of place of birth, place of residence, though we don't need those. And so you might first think, well, so this is an easy case. It's an explicit violation of this provision. The problem, and Josh started to note this, is that there's a qualifying phrase in there. It says, in the issuance of an immigrant visa. I personally think, Josh, that you focused on the wrong part of that qualifier.
Immigrant.
Yeah, I think the key is immigrant. I'm not bothered by the fact that it says in the issuance of an immigrant visa. And actually, I reread the travel ban just recently, and I believe I'm correct in saying it doesn't actually explicitly say that you can't issue visas to these groups. It explicitly bars entry to these groups, and so you could make a stronger case for saying, therefore, it doesn't come within the ambit of the non-discrimination provision, but I think that would be a weak argument, and a practical reason that it would make no sense at all for Congress to pass a law which says you have to issue a visa to a person, even knowing that the person won't be able to use that visa when he or she reaches U.S. territory and presents it to an immigration inspector. So I think we have to adopt a common sense reading which says in the issuance of a visa really means not just in the literal issuing process of the visa, but also in the use of that visa after it is issued. The larger problem, I think, is the word immigrant. It says in the issuance of immigrant visa. Now, the travel ban does ban, the travel ban document does ban immigrants from all of the named countries except for the handful of Venezuelan government officials. So as to them, I would think the violation of this non-discrimination provision is explicit. But even as to the non-immigrants, meaning temporary visitors like students, tourists, and the like, the plaintiffs make an argument that you have to look at this provision in its historical context. It was passed in 1965, which, as many of you might know, if you're as elderly and decrepit as I am, you know this firsthand. Maybe you've heard it from your parents or grandparents otherwise. But 1965 was at the peak of the regrettably very brief civil rights renaissance in the United States. This was the year Congress passed the Voting Rights Act. It was a year after Congress passed the Civil Rights Act. This provision itself, as Josh noted, was part of a much larger civil rights statute that abolished the infamous national origins quota system that had governed immigration and admission to the U.S. since 1921. That system was designed to and had the effect of keeping out Southern Europeans, mainly Italians and Greeks, Eastern Europeans, mainly Jews and Slavs, and East Asians, mainly immigrants from China, Japan, and Korea. So in the light of this entire history and the civil rights spirit of this, the plaintiffs are arguing that despite the insertion of the word immigrant, this provision should be read as reflecting a congressional intent to root out nationality discrimination in our immigration laws more generally. Having said that, I think the supporters of the travel ban have a very fair legal argument. They're asking, if that's the case, why did Congress insert the qualifier immigrant if it really did need to cover people who are not immigrants, who are temporary visitors? And I must confess, I really don't have an answer to that argument. So there are arguments on both sides. It depends on what's more persuasive to you, the literal language or the historical context. On the Constitution, that's the basic gist of the statutory debate. On the constitutional side, the argument again is that the travel ban violates the First Amendment's prohibition on the government establishing a religion. The Supreme Court has interpreted that phrase to prohibit the government from, among other things, favoring some religions over other religions. The plaintiff's argument breaks down into two parts. First, they make a factual assertion that even though the president says that this is all in the name of national security, he is in fact motivated, at least in large part, by his hostility toward Muslims. That's the argument. And secondly, so that's one issue, and that's a question of fact. The second issue is really a legal question, and that is, if the court finds such a discriminatory motive, does that make the travel ban unconstitutional? Well, as Josh pointed out, two district courts, one in Maryland and one in Hawaii, accepted the Establishment Clause argument. They held that the plaintiffs are likely to prevail with that argument, and therefore they issued nationwide preliminary injunctions. A previous court in Washington, as Josh said, had done exactly the same thing with an earlier iteration of the travel ban. Both courts of appeals affirmed the decisions of the two district courts, in one case on those same establishment grounds and in the other case on statutory grounds. And as Josh said, the two cases have now been consolidated. They are before the Supreme Court. The court has issued a stay of the injunctions, which means that at present the travel ban remains in effect until the Supreme Court decides the case. So the merits of the two legs of the plaintiff's argument on the fact question, was this really a discriminatory motive? They start out with the actual travel ban itself. The first two iterations listed 7 countries and 6 countries respectively. Every one of those 6 countries had populations that were, by amazing coincidence, more than 90% Muslim. Now the third iteration does add the country of Chad, which is also a majority Muslim country, but not at the 90% level. And it also adds North Korea, which, as Josh acknowledges, nobody really comes from, only a handful, and the same with Venezuelan government officials. So the numbers of those last two categories, I think, are far too small to change the argument. But that's just the starting point. In addition to what the document itself does, they point to the president's campaign statements, repeated promises that upon being elected president, I will ban all Muslims from entering the United States. This was followed by advice from one of his then closest advisors, Rudy Giuliani, saying, if that's what you want to do, and if you want to really get this past the courts, don't say Muslim, don't say religion, word it in terms of nationality of particular countries, which of course is exactly what they did. Even after becoming president, Mr. Trump slipped up in a couple of interviews. He actually muttered the word Muslim in one interview in talking about the ban. And in an interview with the Christian Broadcasting Network, he assured his interviewer, don't worry, we're not going to be going after Christians. So you have all of this evidence. In addition to that, the plaintiffs introduced evidence that the national security rationale is a farce. That was their evidence. They said, first of all, again, there's no correlation between the listed countries and the countries that are sponsors of terrorism in the U.S. Secondly, even if there were such a link, nationality is a ridiculous proxy for judging whether a person is likely to commit a terrorist act. And on top of all that, they produced a leaked memo that I'm sure the administration didn't want the courts or the public to see, in which national security officials from within the administration said, this does nothing for national security. If anything, it actually harms it. So you might agree or disagree with the court's finding that this likely shows discrimination, but I think it's awfully hard to dispute that there is at least enough evidence to support the finding of the trial court of a discriminatory motive. That being so, the only remaining question really is whether a discriminatory motive would render the statute unconstitutional. If this were in any setting other than immigration, I tend to agree with Josh, this would be a pretty easy case. It's clearly religious discrimination if you accept that discriminatory motive. The difficulty is that this is an immigration case. If you've taken constitutional law, or if you remember your fourth grade civics course, you probably recall Marbury versus Madison. This was the case in which the Supreme Court established early on the power of the courts to declare an act of Congress unconstitutional. But if you've also taken immigration laws, I think some of you have, then you also know that when it comes to immigration, the normal rules of constitutional law simply do not apply. This is because for more than 100 years, the Supreme Court has announced this thing called the plenary power doctrine. The power of Congress to regulate immigration is plenary. The precise consequences of that characterization have changed and evolved over the years, but I think a reasonable generic statement of what the doctrine means today is that if Congress passes an immigration statute and somebody goes to court to challenge the constitutionality of all or part of that statute, the court will still review, but with a very light touch. It will have to be more convinced that the statute is unconstitutional in order to set it aside than would be the case if we were talking about something other than immigration. For that reason, the plaintiffs do have a hard road to toe. But they have two things going in their favor in this case. One is that virtually all the plenary power cases have been about challenges to acts of Congress, not policy decisions of the executive branch. I have to concede that there is language in some of those cases that talks about the plenary power of the political branches, one of which is, of course, the executive branch. But the actual cases have almost all involved challenges to Congress. It is not at all clear today. The state of the law is unclear as to the extent, if any, to which the plenary power doctrine applies to the executive branch. Secondly, even if it does, that doesn't mean the government is home free. They still have to show some minimal threshold of rationality for the particular policy. I'm sure that Josh and I will disagree about how intense that rationality review has to be and whether the travel ban satisfies it, but that at least is the argument of the plaintiffs. That kind of sums up the constitutional debate. Where I end up is, remember, first of all, that in order to win this case, the plaintiffs need only prevail on either the statutory argument or the constitutional argument. My personal view is that the issues are very close on both those fronts. You can probably tell from my comments that personally I would come down on the side of the plaintiffs for the reasons I've given on both of those issues. But there might be some of you cynics in the audience who think for some strange reason that the opinions of the Supreme Court are somehow more important than mine. And on that assumption, the question is whether these plaintiffs' arguments will persuade 5 members of the current Supreme Court. If I have to make a prediction, it would be that based mainly on the predilections of the 5 Republican appointees on the court in past immigration cases, and given also what Josh has pointed out about the actions the court has already taken in the early stages of this case, I think my prediction, and I say this with regret, and with the fervent hope that, as usual, I'm proven dead wrong, that a majority of the Supreme Court will vote to uphold the travel ban. There were a couple of things you've said, Josh, that are very specific, that I would like the time to rebut. I think I'm just about out of time, but Caleb, if I go about 2 minutes over, will you merely shame me publicly, or will you use physical force? Okay, just a couple things. The 1152A1B argument, I think, is a total non-starter for two reasons. 1152A1B is the provision which says the Secretary of State effectively is exempted from the ban on nationality discrimination in the issuance, in the determination of the visa procedure, or also its location, which is not an issue here. Two things, though, two reasons why this argument can't win. One is that the Secretary of State is in charge of the visa process, but the travel ban, whether or not it implicitly bars visa issuance, certainly explicitly bars entry. The Secretary of State has nothing to say about who enters the United States. That determination is within the province of the Department of Homeland Security, and nothing in this provision exempts the Secretary of Homeland Security from the bar on nationality discrimination. That's point one. That alone, I think, destroys that argument. If that weren't enough, the only thing this exemption does is allow the Secretary of State to discriminate on the basis of nationality, or race for that matter, in the determination of the visa procedure. I don't think by any stretch of the English language you can call a decision to exclude people on the grounds that they are nationals of a particular country a procedure. That's a substantive disqualification. If that's a procedure, then any denial of any visa is a procedure, and the practical effect would be to wipe the entire non-discrimination provision off the books. So I just can't imagine the court going that route, at least not going that route in polite company. The Knopf case is interesting. But even there, first of all, the Knopf case is not a binding precedent because it was a 4-3 decision. And if the court had to reconsider that case today, I'd be shocked if it would do the same thing. For one thing, there have been books written about Ellen Knopf and the horrible injustice in that case. And for another thing, the basic principle of the case stands for, which is that once a person appears at a U.S. border, if the person is not a citizen, the Constitution doesn't apply even to the actions of U.S. immigration officials, which assumes they can do anything they want to the person. I can't imagine that even the present Supreme Court would countenance something like that. But even if they did, Knopf is distinguishable. The language might cover some of this case, but the case involved an individual who was found, for some reason, based on evidence about her personal conduct, to be dangerous to the security of the U.S. It was a total sham. She was eventually let in, and the U.S. did withstand her presence. But more important, while I acknowledge that 212F does allow the president to exclude a class of aliens, not just a particular individual, every previous, I have to acknowledge that, the statute says so and previous presidents have done it, but every single exercise of 212F with respect to a class of people in the past, with only one exception, not applicable here, has been a ban not just on nationals, but on a subset of nationals, nationals who possessed certain specific characteristics that could reasonably be described as proxies for the particular objective of that particular statute. The only exception was Reagan's ban on Cuban nationals, and that was designed as a retaliation for Castro's suspension of an agreement that we had with him, and it was meant to send a foreign policy message to Castro. So in that sense, in that case, it made sense to ban all nationals, but it's never been done in any other case. And finally, the use of Youngstown. I don't think Youngstown adds anything to the plaintiff's case, to the government's case. And here's why. The Youngstown argument would have to be that what pushes this into Youngstown Category 1 territory, where the president's power is at its fullest, is the combination of the president's inherent authority under Article 2 to exclude non-citizens, and the grant of authority from Congress to the president via 212F. But that begs the very question we're litigating, which is, does 212F really give the president the power to go as far as this travel ban goes? If it does give the president that power, then that's the end of the inquiry. We're done. You don't need Youngstown, you don't even need Article 2. But if the court says that 212F doesn't cover this kind of travel ban, then we're in other territory. But in that case, you can't really use 212F to push this case into Youngstown Article 1 territory in the first place, because there is no applicable delegation of authority from Congress. I think that settles the statutory debate. On the constitutional side, Again, I think Youngstown fails to answer the crucial questions in the case. Even if Youngstown applies and Article 2 does give the president the power inherently to exclude non-citizens, the basic questions remain. Are there constitutional limits to the president's power? If there are, is the Establishment Clause one of them? If it is, does the travel ban violate the Establishment Clause? So I don't think Youngstown helps to answer any of those questions, and I will stop at that point.
Thank you so much. I'll give two brief points for rebuttal. The first is arguing about subparagraph B procedures. I didn't make this up. The Solicitor General made this argument in a case called Department of State versus Legal Assistance for Vietnamese Asylum Seekers. This is Ed Needler, who's probably the most well-argued advocate for the Supreme Court. And he told Justice O'Connor in 1996 that this phrase, procedures, includes a power to exclude aliens from particular nations based on security concerns. So this is not made of whole cloth. The government's taken the position for decades. And even if you're not persuaded that this is the best reading of the statute, it's a reading of statute that saves the order. And I actually advance this as what I call a saving construction, which Robert's Courts loves to save the statute. The second point, Steve mentioned hypothetical. What if Trump said, I'm going to deny entry to all aliens nationwide, done, done, done? All executive action subject to minimum rationality review and due process clause. I think they'll be completely irrational. But whether we agree if keeping people from certain nations helps security or not, that is too fine of a judgment in the foreign policy context, and one I think the courts are not going to make. I'll leave it there. People will see shuffling, so let's get to questions for you. Right out of time. So questions, please. Let's see call on students from his institution. Questions? Okay, in the back, sir.
Yeah, so one of the things that came up was the separation of powers issue, and what's striking about this case is really a case about presidential power. So I'm actually interested in sort of comparing the current case with the travel ban with the previous litigation with regard to DAPA and potentially DACA, right?
Yeah.
Because there are some differences, but you can say there that there was also a practice and some delegation of power to the president to decide when not to sort of remove.
DAPA wasn't about removal, though. It was about granting lawful presence. Just be very careful.
Here's the thing, right? So what's interesting about that case, and this is similar to the litigation now in Florida with regard to clemency, right, is with regard to whether or not these things are applied in a categorical manner that looks statutory and therefore impinging upon some sort of congressional sphere of power, or whether it's exercised in a very discretionary manner to individuals. So I'm just sort of interested generally, and there's in sort of comparing what has been argued with regard to DAPA and potentially DACA on the one hand, with regard to presidential power, sort of subverting congressional structure in travel.
So a couple of years ago, Steve and I found ourselves on the other side of the debate. Steve argued that DAPA was authorized by the statute. I argue that it wouldn't, because doing so would violate the non-delegation doctrine. That's the same argument reversed. It's hilarious. Times change, right? But the argument there was Congress had enacted some general statutes giving the president the power to the secretary to set priorities in immigration. And the Obama administration said that was adequate to have this lawful presence program. I thought it wasn't there enough. See, for me, in both cases, Article 2 makes a difference. DAPA was never premised on President Obama's foreign policy powers. He never relied on Article 2. I think if he did, I might have had a different answer. But I don't think the statute got you there enough. I think the statute gets you here enough.
I agree with part of what Josh has just said. It's really funny. Conservatives like to argue that we liberals are a bunch of hypocrites because we asserted a bold executive power when Obama was president, and more restrictive one now that Trump is in power. Liberals are guilty of the same charge. They accuse conservatives of being hypocritical because they favored a narrow construction of presidential power for Obama and now a broader one for Trump. Frankly, I don't think either side is being inconsistent, let alone hypocritical, because the legal issues in the two cases are just completely different. They both turn on different statutory provisions. They both raise different constitutional issues. So I tend to think that one could principally take either view in either of them.
As we have. No, we're actually here in good faith. People throw around hypocrisy charge way too much. Students, the laziest attack you can make in someone is calling them a hypocrite. It's the absolute laziest thing you can do. Make an argument, just call someone a hypocrite. It's too easy for cable news, but you're better than that. I mean that. Other questions? Maybe one more. Okay, yes, sir, in the back.
I'm not sure if this was asked yet because I walked in a little late, but what are the political speeches that happened during the campaign still relevant to the travel ban, particularly when it has changed now in its, I guess, current?
Yeah, that's a good question. I'll take a stab. my position, and I'm going to argue this firmly, is that campaign statements are off limits. I think there's a serious chilling effect for courts to start bringing in campaign statements. Post-inauguration, I think it's actually fair game, but the foreign policy context with a minimum rationale review is simply irrelevant. You don't need statements with this sort of standard review.
I'm going to strongly disagree. There are people who believe, and there's some truth to this, that once a person becomes president, he or she can change his or her views, and I credit that. I don't discount that. That's an argument for saying that statements made on the campaign trail are less probative of the candidate, of the person's intentions and motives than the same statement would be after inauguration. I don't see how that's an argument for saying that they lose all probative value. If a person says over and over and over again, I'm going to ban Muslims from the United States, it hardly seems intuitive to me to say the moment the person becomes president, we can assume the person didn't really mean that. Either the person was lying, which goes to the credibility of the post-inauguration statements, or the person really meant it, in which case that does tell us something about the person's view toward Muslims. So I think those statements are probative, and in any event, in this case, they are combined with a couple of slip-ups that occurred after inauguration.
Yeah, I'm not going to bore you, but I've read about the post-inauguration statements. They're, as usual with Trump, he can be interpreted in many different ways, but I'll leave it there. All right, other questions? Yes, sir.
So it seems like this is a really close case, statutorily and constitutionally, and you both have very different views. And I don't think personally that there's an answer in either the statute or the Constitution. So would you either or one of you or both of you be willing to admit that just comes down to the 5 votes on the court?
No, I'll actually disagree with Steve again strongly. I don't think the Supreme Court is some sort of gospel. I think that John Marshall was wrong. A lot of things was wrong on that particular Marbury. But when the Supreme Court writes an opinion, they're not only focused on what's going on today. Lower court judges, they're very much in the news, they're saying tweets. When the Supreme Court puts an opinion in the U.S. report, it's been read for decades. Not just when Trump is president, but when Bernie Sanders is president, or Elizabeth Warren, or Malia Obama, whoever happens to be right, they're writing opinions for the long haul. The sort of opinion from the lower courts is not the sort of thing the Supreme Court wants to adopt for decades to come. Now, Steve Barton's talking, what about Korematsu, right? You look at an opinion like Korematsu, and they look at that back in infamy, right? You're looking at this bigotry held by the Supreme Court. I was in the courthouse this morning, and the Dred Scott case began, right? The challenge was to say, this is me, Dred Scott, this is me, Korematsu. I think it's going to be like James and Morgan Regan, where in decades people say, well, you know, this was a blip. It was a policy that affected a fairly small number of people. We weren't citizens, didn't have rights. I don't know. But I think in the big picture, the long scheme, the court will say presidential power here trumps, even though this policy has really been fairly narrow and will affect this fairly small number of people. Steve, disagree?
Well, I partly disagree. Since Bush v. Gore, I am no longer under the delusion that Supreme Court justices are insulated from their own personal political preferences.
But
I
go, Steve.
but I don't want to suggest that judges are unprincipled. It does seem to me that Alito, Thomas, and Gorsuch, they're going to vote against, they're going to vote to uphold the travel ban, no matter what the arguments are. Roberts and Kennedy might listen to the arguments, but in the end, I think it will come down to the votes of people who are unavoidably influenced by their own ideologies. We're all human beings. We all have views that are influenced by a number of unconscious biases that we find it very hard to ignore. So,
my biases are explicit. Thank you all so much.